Welcome, welcome, welcome to Challa Law's weekly webinar. It is March 9th, 2020, and we've got a lot that we're going to be talking about. Let's give people a few minutes to join, and then we'll get started. Before we even get started, let's make sure that yesterday was Women's Day, and what I had posted about was honoring or sending our thoughts and prayers to all the people in Ukraine that are just undergoing this horrific, assault on their country and having to flee. But, we can also get inspired by all the amazing women that have been coming out in arms to defend their country and to defend democracy. So it can be inspiring for all of us. So with that, we can get started with our breaking news. Like I said, I'm trying to give folks a few minutes to join. And I know some people have already got their hands raised, and we will have a Q&A at the end of our session. So, like I said, giving folks a few minutes. I hope it's warm and sunny where you are. It is a little cold for us today. So it's like one day it's super hot. You think I've got to put my sweaters away. The other day you're slightly freezing. So I hope it's warm, like I said, where you are, so that here we go. And let me see if I can shift this over. It is crazy with multiple monitors. I forgot that with multiple monitors there's something we're supposed to do, but I hope you all can see this. There we go. So breaking news. EB5 center reauthorization may be part of the omnibus spending bill. So if passed, EB5 investment would increase to a possible 800,000 from the current 500,000 for the there we go, for the targeted employment areas. EB5 reauthorization continues to progress as expected as part of the overall U.S. government omnibus spending bill. Senators Grassley and Leahy continue to craft their own language, which may be modeled after the bill that got rejected in June, with some additions that are likely to include, like the price adjustment, clarification of the TEA definition, and grandfathering of current and previous investors, and some more minor additions. The draft of this will likely be available before the Senate sends a full omnibus bill, which the House will likely vote on either today or tomorrow. And but the deadline is for Friday, March 11th. All indications show that the omnibus spending bill will be voted on and will pass both houses and will be signed by the president. So, like I said, if it's passed, the EB5 investment amount would increase to a possible 800,000 from the current 500,000 for the targeted employment areas and rural areas, and a 1.5 million from the current 1 million for the non-targeted employment areas for both regional and direct investment. And so will the bill take effect immediately? Usually not. There's usually a period after it's signed that the bill takes effect. So as a practice pointer for all of you that are thinking about, should I or shouldn't I? You should, and you should do it soon. Invest in either as a direct investment, or if this gets passed, in a regional center to leverage the current 500,000 for targeted employment areas, because you save $300,000, which is not a small chunk of change for that decision. And then the other thing in the news that Congress does push on DHS to improve their contact center, the reinstatement of the InfoPass and other self-scheduling systems. Remember, when COVID hit, the USCIS stopped taking InfoPass and they haven't reinstated it. And that was one way in which people could actually go to the USCIS and get their issues resolved. Providing accurate and accommodating callback windows, allowing a law firm or their staff of record to make requests, trying to make the granting of appointments through an info mod to be made public so they can understand what the criteria is, and offer walk-in availability for urgent requests. 47 members of Congress wrote a letter to the Secretary Mayorkas and Director Jadot. Pending caseload has increased from 85% from 2015 to 2020. As we reported last week, I think there are about 9 million cases that are currently pending before USCIS. That's a lot. So that is the main issues in the news, not too much in immigration because of everything that's going on, things that need to be in the limelight are kind of taking a back seat. I want to welcome all those people who are joining for the first time, and for those who are great supporters of this webinar every week. We strive to give you important content and information that you can use to, achieve your immigration objective. And also hello to all the live people on YouTube. Can't see you because I don't know how that functionality works, but thrilled that you're joining us today. Now, the main subject for today was to talk about, okay, so I don't get selected for, oh, here it is, let me bring it over. I don't get selected for the H-1. What are some other options for immigration processing? So today we talk about the O-1. The O-1 is deemed extraordinary ability. So how extraordinary is the question today. So people, when they think of extraordinary, of course, you think of Einstein, believe it or not, Justin Bieber. And you could probably have your individual opinion whether you think he's extraordinary or not, came to the United States on an O-1. But it's been used for a number of people, for world-renowned chefs, for business folks who have maybe innovative products or maybe innovative processes. And then, of course, people who have come up with great research and other things. It's been used for soccer players, of course, clearly musical artists. So you shouldn't, when you think about how extraordinary is extraordinary, you gotta sometimes think outside of what you normally would think that word means. And that's what we're going to talk about today. So the O-1, there's O-1A, individuals with extraordinary ability in the sciences, education, business, athletics, not including the arts, motion picture, or television industry. And there's O-1B for extraordinary ability in the arts, or motion picture or industry, or the television industry. The people who support the O-1s can come in as O-2s if they have played a critical role in assisting the O-1 in some capacity. Example, you have an O-1 chef. So the O-1 chef would be eligible for the O-1, and those supporting the chef, meaning the sous chef or the chef de, the dessert chef, and all those other individuals would be able to come in to support the O1 chef on an O2. So with 101, you could be, bring a whole bunch of supporting O2s. That's something a lot of people don't realize. The O1 is valid up to 3 years with extensions in 1-year increments. There is a path to permanent residency. And along with the O1s, there's something that's called an advisory opinion. So you have to obtain an advisory opinion, depending on the type of O1 you have, either from a peer group, like a labor union or some type of, or experts within the field that would give their advisory opinion about your extraordinary ability. So you can either win one major award, like the recipient of a national or international award, but it's more geared towards a major international award. And they cite as examples an Academy Award, an Emmy, a Grammy, or Directors Guild Award. But you've got to be creative with this. So you either win one major award. So this major award could be a major award in your industry. We've talked about how someone who is a branding director, a branding specialist, who helped this one mall. She created the brand for one mall in France. That particular mall won one of the best development awards in the world. And I looked at the caliber of the awards, and they were amazing. And they even had a red carpet out for the award ceremony. And so even though she didn't get the award, it was the developers that got the award. We were able to link back as to how she contributed to the outcome of the developer getting the award. So, you've got to be creative, make sure you can make the links. If you can highlight other people, accomplishments of other award recipients, that can really show what the caliber of the award is. And then who are the judges who actually judge these award ceremonies? So I always try to meet this criteria if I can. And you either win one major international award, or you win 3 out of the 6 criteria, the other criteria that they outline. So you argue that, and then you argue that the person has met, 4 out of 6 or 5 out of 6. Try to meet as many of these criteria as possible. So one of these 6 is evidence that the foreign national, and the word alien is in there because that's how it is in the regs. Don't mean to offend. I find it a strange word, but anyway, evidence that the foreign nationals performed or will perform a lead or starring participant at production or events that have a distinguished reputation, as evidenced by critical reviews, advertisements, public releases, publications, contracts, or endorsements. Now, I told you there's O1A and O1B, and they're very similar. The language will be a little different as to what the playing a critical role is, but it's playing a critical role. So the critical role, as I demonstrated with the example I provided about the branding specialist or expert, doesn't have to be direct. It can be direct or indirect. But the main thing is you've got to be able to connect, the distinction that was received to the O1 applicant. And you can do these through letters, through, a number of different ways, but that link needs to be created. Evidence that the foreign national has achieved national, international recognition of critical reviews or other published material about the individual in major publications, in newspapers, and otherwise. And you can use, there may be, an award of distinction that could be deemed a major award. It could also mean, like recently we crafted an extraordinary ability for a music engineer, sound engineer. And that person was, inducted into the universities, which is a very famous university for sound engineers, into their Hall of Fame. So I argued that that was an award. I also argued that that was an achievement of a notable recognition. And so you can have evidence that can fit in multiple categories. Now, even with this, one of the critical things is that you've got to make sure you outline the caliber of the achievement or publication. So, what's the readership? If it is a major achievement, who received the awards before or recognition. So you want to kind of highlight the caliber of the evidence. So it's not just you can throw something in, a blog post or where somebody said that something was good and that would be good enough, because unless the blog post was by someone who is renowned in critical reviews, it's not going to have the probative value. Second, evidence that the foreign nationalist performed or will perform in a lead, starring, or critical role for organizations or establishments that have a distinguished reputation, as evidenced by articles, newspapers, trade journals, publications, or testimonials. So let's break this down. That the foreign nationalist performed or will perform a critical role, that means it's not just that they're employed by, but the role that they have is critical for, in an organization or establishment that have a distinguished reputation. So it doesn't necessarily have to be just the role that they're currently doing. It could be even roles, previous employment where they have worked at other organizations. And, a lot of times the credit doesn't go to, especially if you're with a large multinational, the IP credit remains with the organization, right, for the most part. But you can get letters from folks that talk about, what your role was. And there may have been newspaper articles that may not have mentioned your name, but have mentioned, the product or, the IP or the, whatever it is that, is supporting your extraordinary ability. So, with the sound engineer, it was artists that got a lot of the recognition, but because he was the sound engineer for those artists, that's a way in which you can show the causal effect of the individual's, critical role in someone else's success, if you will. Evidence that the foreign national has a record of major commercial or critically acclaimed successes, as evidence such as indicators such as title, ranking, standing in the field, box office receipts, motion picture and television ratings, or other occupational achievements reported in trade journals, major newspapers, or other publications. One other O-1 that we were very successful with is someone that made buffalo mozzarella, which on its own, you may not think it's so critical, but this individual made buffalo mozzarella in Colombia. And everyone kept saying that this cannot take place because they didn't have the infrastructure. They didn't have, they had the buffalo, they had a lot of buffalo there, but they never made buffalo mozzarella. And especially not to the standards of something that would be sold at like a Whole Foods, because Whole Foods has this whole process that they go through. But, and the person who was the face of all of this was more on I would say, the operations side. But the individual that crafted the logistics of not only how to create that in a country that did not have the infrastructure or the trained individuals. So they worked with the indigenous community there, trained them on how to use, instead of doing it manually, on how to use these machines to go about doing this, how to make sure they maintain standards, how to bring it over from Colombia to the US on boats that were already bringing flowers, and thereby creating a zero environmental footprint as a result of the transport. So, but his name was nowhere. But that was the piece that was the most critical. So we were able to show evidence of how, everyone thought, even the US Secretary of Agriculture did not think it could happen. We had that letter, we had publications and everything else that highlighted the person who's heading up operations in Colombia. But then we had the individual in Colombia whose name was everywhere to talk about what the accomplishments of the really creating the logistics part and how critical that was. So you have to kind of not think, sometimes you have to think analytically about this. You have to make sure all the pieces of evidence connect, but it doesn't necessarily have to be direct. Evidence that the foreign nationals received significant recognition for achievements from organizations, critics, government agencies, or recognized expert in the field. So usually these petitions are all, they're submitted with expert support letters. I always like to get a variety: industry, academic, government. You have to establish the credibility of the experts. So it can't be just anyone that writes the letter. That person has to, have the, you have to first establish that this individual has the expertise to write this support letter. And they can't say, I can't tell you how many times I get letters where they'll say, oh, this person's such a great person, nice to work with. No, that is good. We're happy to hear that. But that doesn't help in terms of evidence to establish this person's extraordinary ability. They need to outline specific accomplishments and how they achieved them and why they're notable, and how the expert has knowledge of this industry or those accomplishments are very important. And last, evidence that the foreign national has either commanded a high salary or will command a high salary or other substantial remuneration in relation to others in the field. It's not always applicable, especially in innovation. You don't see the money up front. You usually see it later on, but a good baseline to help you assess whether this is a means by which you can, this is a criteria you can meet, is to go to the Department of Labor, their online prevailing wage surveys. They're geographic, they're specific to the geographic area and to the particular occupation that the person is currently working. So you can look at that and say, okay, this is what is supposed to be standard based on what the DOL states for a person they should be making X amount of money, and this person is making so much more. That's one piece of evidence that you can use to show that they meet this criteria. So extraordinary, everyone is extraordinary in their own way. So there's no clear definition of what is extraordinary. There is criteria, but like I said, you have to be innovative and strategic when you think about this. And you got to take some time to really understand what it is that the O-1 is doing, which is why I love doing O-1 petitions. And there are often times where even the individual that we're doing the O-1 petitions for has no idea that there is all this material about them. So how extraordinary is extraordinary? Well, it's as good as your lawyer can craft. That's what I would say, because everyone's extraordinary. So next, that is our piece for today. So next is our time to talk about, get the Q&A. But before we get the Q&A, I am going to ask folks to, my ask every week, right? Where are you? There you are. So my ask every week is, if you are enjoying our webinars, please, sign up. We've got a Telegram group, Clarity for Hum Forum, but it's trying to provide clarity on the immigration answers. And in Hindi, hum means us. So it's us, clarity for us. And it is a community of folks that are going through various types of immigration issues, and a great resource, a good sounding board. So and if you want to join, all you got to do, if you're on your computer, if you're not on your computer, then Lainey will send out links in the chat. But if you're on your computer, just put your phone right up there and the link will come up and you will be able to join us in our Telegram community. If you like our weekly webinars and your first time joining, register. That way you'll get notices of when the webinar is taking place, what the subjects will be. You can even, if you do this, you can share it with your friends if you found it helpful. Again, if you're on your computer, you just put it up there, the link will come up and you can copy it and send it off to your friends. And that would be great. We can increase our webinar community. And then finally, a lot of our information is on our YouTube channel. Anything from issues you should look into between filing EB2, downgrading to EB3, interfiling. Can you have two adjustments? Can I travel while my adjustment is pending on my advanced parole without jeopardizing my H-1B? All these questions are answered on our great YouTube channel. So, and the only way you'll know if we created new content to upload it into our YouTube channel is if you subscribe. So again, you put your phone up, the link will come up, and then you can subscribe, you can share it with your friends, and we would love to hear from you. So with that, I am going to ask Shaker Challa to, I believe he's here. He's somewhere ready to moderate for today's event.
Good afternoon, Lakshmi. Good afternoon, everybody. Can you all hear me okay?
Yes.
Can you, do you also get any background noise?
Not that much.
All right.
Shaker doesn't believe in wearing earplugs. So.
Sorry. Old school. Feel claustrophobic. It's nothing on Q&A right now, but let's go to the chat. I saw a sweet seller. Every day, every Wednesday, the sweet seller is back. So from YouTube, sweet seller is asking, USCIS live agent mentions all cases at NBC would be adjudicated at FO. Is that true? Do FOs process cases pertaining to their jurisdiction only, or do they process cases nationwide?
No, field office. FO means field office. So yes, so when the case is getting ready to be finalized, it gets sent down to the field office that has a jurisdiction over where you currently reside or where you indicated you resided on your application.
Sweet Swellers, another question. Any updates on DHS pending bill? Is this the same bill referenced in VB, which mentions to EB5 getting impacted by EB2?
Right. So yes, I think we discussed this last week that that if EB5 regional centers are reauthorized, the visa bulletin said that EB2 may get impacted. So we just have to wait and see. Like I said, there's a number of factors that affect the visa bulletin, but because the USCIS was not adjudicating the EB5 regional center applications, they were put in abeyance. It just depends on where they were in the process, how many were ready for adjudication. You know, there's a lot of factors. So
that's the next, I think the sweet seller is, if the bill regional center reauthorization you're referring to passes, when do you think the impacts would be felt on EB2, EB3?
as I said, you're not going to know anything. We don't have the first quarter report yet. And so we don't even know what the processing has been. We've looked at, if you look at you were there, Sweet Seller, I remember for, I think 2 weeks ago, or maybe a week ago, we talked about what the processing times had been, or how many adjudications the USCIS had been doing within a certain quarter, and then we broke it down per month. We also know that Congress did give DHS $250 million to decrease their backlogs. But they've got to, hire more people, train them, so that takes some time. So we'll have to, I think, first and second quarter would be a good indication to see where we are. We'll also have numbers from DOS at that time that will give us better idea of what the processing is of these immigrant petitions overseas.
Next question from YouTube, V. Lakshmi. My daughter converted from H4 to F1 after turning 21 and her I-485 pending and received I-131, not applied EAD. If she travels using advanced parole, what happens to her H1, F1?
Right. So that's a good question. So if you're on an H or an L, they're dual intent. So you can intend to reside here in the United States temporarily. You can reside here permanently. So those individuals can travel without AP on their H visa or L visa for all other non-immigrant classifications. Until you receive your advanced parole, you cannot travel. So your child will be able to travel, but they will not be F1s anymore. She'll be an adjustee. And that's probably better. And I just need to know this. When you say you've got an I-485 pending, is that based on, so was she under the age of 21 when the priority date was current?
You can answer in the YouTube chat and we'll pick it up. But we'll go to the next question. Raju from YouTube. Do we expect any FB spillover to EB for 2023 year?
Do we expect any?
FB, F for Frank, B for boy.
Oh,
F
yeah.
EB.
Yeah, family-based. What he's asking is if they think any family-based, there'll be any spillover. We won't know until we find out what's happening with the DOS. Because remember, that was because immigrant petitions, which a lot of the family-based petitions are processed overseas, a vast majority. So because of COVID and the consulates closing, the employment-based categories were able to leverage on the fact that there were a lot of unused family-based. Now consulates are starting to open up again. So again, first quarter, second quarter, we'll know how the usage is.
The next question from Sweet Seller. Will the regional center EB5 bill take away the 290K spillover from FB to EB?
Sweet seller. We can't predict any of this until we have all the numbers. As I said, there are a number of factors that impact the visa bulletin. USCIS processing time, the number of immigrant petitions that are processed overseas, all of that impact the visa bulletin. So until we have clear numbers, it's hard to make any type of prediction. There's only speculation.
The next question from YouTube, Hunter is asking, my parents' B2 visa expired in 2016 and they want to apply again now. Is there any interview waiver for them?
2016, I think the Dropbox, it would have had to have expired in the last 2 years. So I think your parents are just outside of that and then some. So I think they will have to go for another interview.
Another question from YouTube from SP100. I do have birth certificate for I-485, but the birthplace is not correct, but all other information is correct. Can I submit the affidavits from my parents with notary sign to support my birthplace?
Yes.
All right.
Isn't there any way you can get a letter or something to, why was it incorrect? Is it because they mentioned, because sometimes what they'll mention is the Challa or the, what do you call it? It's not really the state, but the birth certificate will mention the larger geographic region instead of the specific village or town. So if that's the case, what we've done is we've taken a map and we've shown that, you know, they've mentioned the province or the Challa or whatever, and this town is located within that. So it is not specific enough, but it's not incorrect.
All right, got some questions in the Q&A box. Hardik Panchal is asking, the student who has overstayed after the I-94 expired, married a US citizen, but hasn't filed for the green card yet. How soon can that student get a green card or an advance parole document if need to travel India immediately? Can the student leave the US after filing, or should the student wait for the advance parole? And on advance parole, if one travels, will they have issues when coming back to states as they have violation on staying after their I-20 or I-94 expiring on F1?
Oh, geez. This is like a law school exam question. So let's start from the beginning. F1s are, their I-94 says DS. So duration of status. So they usually, you know, there should not be a date on there. So duration of status means until they've maintained status. They don't accrue unlawful presence, which triggers the bars, the 3-year and 10-year bars, unless there has been a judgment by an immigration official or a judge. So that means if they filed a petition for change of status with the USCIS and the USCIS denied it, well, that's when they start accruing unlawful presence. If they just, after their program was over, overstayed, then there has not been a decree by a judge or a DHS official, then they don't accrue unlawful presence, which is really critical for the bars. Now, since they made a valid entry into the United States and they were inspected, when they marry a US citizen, they can become permanent residents of the United States. However, the person should not, definitely should not travel till they get their advance parole. And there have been some CBPs at the port of entry that have claimed that, that you're making a reentry into the United States. And so it would all depend on the factors I outlined at the beginning, whether they had their I-94 said duration of status, and whether there was any DHS, USCIS, or judge that made a negative determination on any of their applications.
The next question is from Majid Yusuf. I got revocation on I-140 and my employer attorney said they don't share with me anything NOIR/revocation notice. I am the beneficiary.
How do you know it was revoked?
Why they don't share?
Well, two things. Number one, you have to know, we get all our clients to sign this when we work on their, especially the PERM process, the PERM related permanent residence process, that it's dual representation. You're representing both the employer and the employee. And as a result, when there is a conflict, the attorney has to withdraw representation. But just because he's representing the employer doesn't mean he can't share with you at least some of the notices that he's received. They can redact any privileged information out of there, but they should be able to give you that information.
This next question is from AA. My 485 is pending since October 2020 in EB3 category. My EB2 140 is still valid and might get current this month. Bulletin. I'm planning to request for interfiling. My question is, can I leave the current company after filing interfile for EB2? What is the impact on application?
Yeah, every time you interfile, you have to wait, it's like that AC21 clock is reset. So you have to wait 180 days before you can change employers.
Well, those are the questions right now, but while we're waiting, maybe we can update on the speculated bill that is that's coming up on EB5. I'll leave it to you.
Yeah, no, I don't know if you listen. I don't know if you listened to the. I said I don't know if you listened to the first part of my presentation. I talked about the EB5 reauthorization bill.
I missed it. Sorry.
All right, Daniel. You know who's going to be in the doghouse after the program today. But I did talk about the EB5 reauthorization, and I said that because it is likely to get passed, but we suspect that it won't be effective immediately because Friday's, just 2 days away, that people who are thinking about, trying to leverage the $500,000 investment should do that now. And if you have any questions, you can email us at info@challalaw.com on any questions related to EB5 and direct or regional center investment.
Yeah, please email, and I have a great project to recommend you. I don't know if you're just interested in the green card, so I'm glad to share all that information. So love to talk to you guys at your convenience. Don't have
Good.
Nor do I have anything on the chat. So
Okay, wonderful. Well, let us know if there's a topic you want us to cover. We'll be happy to cover it. And next week we will probably, this week we did the O-1s. So next week, we may get back into, issues relating to H-1Bs and permanent residents.
There's a question from Hardik Manchal. A friend's business visa was canceled at Abu Dhabi airport when the officer found that the visitor stayed close to 5 months in 3 trips out of the 5 past trips in the past few years. Also, a chat on the phone with a friend was found by CBP officer that said he might apply for a work permit and SSN in his upcoming trip on a separate U visa, BFD, that was under process. CBP canceled B1 and asked to apply again without barring, asked to withdraw entry request and processed cancellation. There's no question here. Maybe he's just trying to.
Right. So the good thing is, when the individual did did a smart thing. When you are being inspected by CBP and there is an issue, they will often ask, do you want to withdraw your request for admission? And you should always say yes, because at that point, if you don't, and you push, as I had one of my clients, HR execs do years ago, you get put in expedited removal. And that was my first expedited removal case that I had to take care of and she thought she did a great thing. I kept telling her when she was at the Dulles airport, I was somehow able to talk to CBP. They wouldn't let me talk to her directly. And I said, I will suggest to her, and I told her employer, have her withdraw her request, get on a plane, go back, and then come back again, because then it is without prejudice. That means it does not impact any future requests for admission. But she thought, let me show my, my tenacity and push my way in. And so she was in expedited removal proceedings. Luckily, that day, the judge was somebody I knew. I was on a panel with that judge just the previous year on immigration and criminal ramifications. And so, she actually, even before the hearing, she saw me and she saw my name listed. So she came out and so my client, needless to say, got to benefit from not only my great representation, but the fact that the judge had a tremendous amount of regard for me. So what your friend did was, number one, it was a good thing, that they canceled it without prejudice. Number two, this is a good wake-up call for everybody who is traveling, that when you come into the United States on a particular visa, you're coming in with a specific intent. Now, on a business visitor visa, you can explore investment opportunities, you can go to meetings, you can do all those things. But if you say on the onset, and then after you enter, after 90 days, you can change your mind and then change to another status. But if you have that preconceived notion, even before you walk into the United States, that means you have misrepresented your intent. You had a preconceived notion to change status. So that is something that everyone should be aware of. And got to do it the right way, folks. Got to do it the right way.
Hardik Panchal is just, I think, the person has traveled for 14 years without any issues ever, had a business visa renewed once without any issues. How do we get over the issue and get a new visa?
You can just apply and just say that, I don't know. I mean, if it's truthful, he can say, he just was talking about possibilities, but he didn't have a job lined up. I don't know what the details of, his situation is. And I would never ask anyone to lie to a government official. So whatever within the confines of within the truth, whatever's the best explanation as to why he had that text, and trying to show it was more theoretical than actual fact-based would be, if that is true, would be my best suggestion.
My suggestion is if you're traveling and if you're in the CBP zone, don't pick up the phone and don't do any texting and just turn the damn phone off. That's the
Yeah, but
best strategy.
they can look at your text messages, your social media.
So as soon as you land in any country, you text message your family and friends and say, hey, I'm going to be entering the CBP or the immigration zone. Don't call me. Don't text me. I will call you when I get out. So that way, there's no issue.
And be cognizant of the fact that they can look at your device to see if there's anything incriminating on it. So.
Yeah. Let's see. That's Arthik Panchal. That's true. They actually didn't have any job. It was just stupid chatter. Chatter is chatter. Chatter can't be stupid. It can be picked up. The guy is renowned business person in India and US with a US subsidiary company. Super duper. You both are the best. Thank you. Thank you, Mr. Panchal. Appreciate it. Sorry if I was very cutthroat and curt in my response, but sometimes you got to do that. Just don't answer the phone.
Well, I want to thank everyone for joining. I want to thank my team for their tremendous support. Lainey for making sure all this information gets out. And thanks Shaker for his, as he's waiting to pick up our daughter at Dulles Airport, which is now going to be a lot longer than originally anticipated. I want to thank him for chiming in and moderating today. And I look forward to seeing you all next week. We can recap on some of the issues that relate to downgrading and portability and new adjustments and strategies, and talk a little bit about H-1Bs as well. So tune in, and I look forward to seeing you next week. Until then, you all stay safe and have a great weekend.